Hello, I'm Chris Griswold. Thanks for joining me this month for another topic. This month we're talking about business terms, just explain business terms. I'm picking out three different phrases: good faith efforts, reasonable efforts, and best efforts as something to explain just to a general audience because those are normal terms that come up in a lot of contracts that people sometimes use without consulting lawyers, and they want to just have a better understanding of what they're looking at. And I do it to make the whole business world work a little bit smoother. But I basically introduce the three terms in the context of a purchase sale contract that is between a buyer and a seller, and it puts it incumbent upon the buyer to not disclose any confidential information that's learned during the due diligence period. Under good faith efforts, the buyer would have to use some sort of actual effort to not disclose that information that it obtained from the seller to some third party, just whatever that actual effort is. Under reasonable efforts, the standard to put upon buyer would be a reasonable person standard. If a leak later occurred, well, did buyer act reasonably in trying to prevent the leak? That got the info out to third parties. And under the best effort standard, it's an impossibility standard. If a leak later occurs, then it's just implied that the buyer did something wrong just for the leak to have occurred in the first place, unless somebody died behind the wheel of a car and couldn't communicate in time to keep the leak from happening later on. But that's how those terms work together. Thanks. Bye.